Thank you for spending your time with us. If you're just joining us, you're in the right spot. If you're looking for the Central Massachusetts Vesta Hub presentation on child support, alimony, and parenting strategies. Vesta Divorce, the organization. It was founded in Boston, Massachusetts in 2013. It has helped over 10,000 people at this point navigate through divorce and separation to achieve healthier outcomes. And Vesta is made up of different hubs of vetted divorce professionals in core areas of legal, home, financial, coaching, and therapy, as well as a robust group of ancillary service providers who work independently or as a team to help you through this difficult transition. There is now a national presence of hubs across the United States. There's new ones that are popping up. There's a new one in Connecticut, in Colorado, they're in California, all over the place, offering complimentary monthly webinars like this one on relevant topics. And there's also a library of on demand videos that are accessible at any time. And there's also a dedicated team of empathetic concierge specialists who will help guide you through your process and providing you resources based on your stage of divorce and specific needs. This concierge service is complimentary to the Vesta community, so please feel free to connect with them afterwards. And we have one of our concierge specialists here, Mandy Pullen-Barr, so I'll invite Mandy to come on and say hello.
Thank you so much, Julie. Hi, everybody, and welcome. We are delighted that you are here with us this evening. Of course, we're not delighted of the circumstances that you find yourself in. Obviously, navigating divorce is a emotional time requiring a lot of decisions to be made. We are glad that you found a resource that can help you get educated and understand so you can make informed choices. You're going to hear a lot of information tonight, so please grab a piece of paper and a pencil, take some notes so that you can begin to think about who you need and on your team, whether it be this whole group of amazing professionals or it be one or two of them. And it would be my pleasure to speak with you to help you figure out who you need on your team. I put my contact information in the chat. You're welcome to schedule a call using the link, or you can call the 800 number, whatever is easiest. And for everyone that is here live, you will be getting our divorce interview guide that gives you some great questions to ask the professionals when you have your consultations so you can really build a team that is aligns with you and your goals. So I look forward to sending that out to you tomorrow morning. So thanks.
Thank you, Mandy. So, we're going to start off going around the group, introducing ourselves before we dive into our formal presentation on tonight's topic. My name is Jolie Vacchi. I am the founding attorney of Foundations Family Law and Mediation Center based in Worcester, Massachusetts, where we resolve family law conflicts as painlessly and peacefully as possible. I am also a certified mediator, a collaboratively trained attorney, and a coercive control trauma informed attorney. The majority of my practice centers on divorce work, and I also co host a podcast with our lovely divorce coach, Lisa Happ, called Divorce Detox. If you'd ever like to check that out, we have over 80 episodes at this point. And I very much believe that education is empowerment, especially when it comes to the divorce process. When you know what your options are, you feel less stuck and arm yourself with the information and support you need to make informed decisions to help you move forward. And that's why I'm so happy to have been partnered with Vesta for over 2 years now, because they offer that through their educational programming, such as tonight's webinar, and through that complimentary concierge service to help you create your own divorce dream team that's tailored to your needs. I'm so excited to be here with you tonight to hopefully help clear some of the fog about what may potentially lie ahead for you. And I look forward to speaking more during tonight's presentation. And with that, I will turn it over to David.
Good evening. Excuse me. My name is David Meyer, a certified divorce real estate expert. And what that is just a realtor that has specific training in the field of divorce. I'm licensed in Massachusetts and New Hampshire. I have a past experience in law enforcement, which comes very handy with a lot of these situations as well. And I'll be putting my information in the chat. So if anyone needs to reach out, they can get a hold of me.
How about you, Maggie, up next?
Thanks, Julie. Hi, everybody. Good evening. I'm Maggie Eck. I'm a certified divorce lending professional and a loan officer, mortgage loan officer. So I help people navigate the divorce process, determine their different lending options for when they're trying to figure out if they can maybe buy the marital home or purchase a new home and what that looks like in their specific situation. Also, here to help be part of your team and support you so that post divorce you're successful. I'm going to put my information in the chat, my company, Divorce Mortgage Planning of New England, and I'm happy to help anyone. Thanks, Julie, and everyone.
All right, Marty.
Great. Hi, well, okay, you can hear me. Hi, everyone. I am Marty Chadwick Balcom. I am a divorce attorney and mediator. I've been doing this work for about 27 years. And after a long time being a litigator, I now focus my work exclusively on mediation, collaborative law, and divorce coaching with the intention to help individuals and couples navigate divorce in a more thoughtful, efficient, and less adversarial way. I'm also someone who has been through my own divorce, so I understand that it's not just the legal complexities that we're dealing with, but the emotional and very human side of the process. So, what makes my work a little bit different is that I center nervous system regulation in everything I do. And in my experience, most decisions made during divorce are not just legal, they're physiological. And when people are overwhelmed or in a stress response, it's so much harder to think clearly, communicate effectively, and make sustainable agreements that last. So, my work is to help clients stay grounded and regulated so that they can co create an agreement that is going to work to support their next chapter. I believe that when people are given the right information and the right support, you can move through divorce with more clarity, control, and less unnecessary conflict. So that's why I'm so aligned to work with Vesta. I love this team and the work that we do, providing education and access to resources so people can make the informed, empowered choices. Excited to also say I am the host of the soon to be launched Regulated Lawyer podcast that will be coming out in June, where we talk all about nervous system regulation and sometimes the law to bring that home in a different way. I'm located in Amesbury, Massachusetts, but I work with folks virtually as well as in person. And I'm so glad to be here and be part of the conversation. I'm looking forward to talking with you tonight. So thank you.
Lisa.
Hi, everyone. Thank you all for being here. We know how hard it is to hit join, to hit start at the end of the day. You've been at work, you've been taking care of kids. And if you're in the same part of the world as us, it's absolutely beautiful out after being cold for again 6 months. I think it's one of the first nice days. So I know it's really hard for you all to sit down and show up tonight. And also, congratulations. I think often when people start the divorce process, the first thing everyone says to you is, I'm so sorry to hear that. But honestly, like you're starting a new chapter of your life. Maybe you wanted the divorce, maybe you didn't want the divorce, maybe you're not sure. But wherever you are in that realm, it's really hard to get there. It takes years sometimes of I work with women for years and years sometimes before they even come to the realization that they are ready to do it. So congratulations, however you got here, because it sucks having people say I'm sorry to you all the time. I am a certified divorce coach, coercive control recovery coach, and grief coach. And I work internationally. I travel all around the world, getting people divorced, going to court with them, working with their attorneys and their teams to build legal strategy and coercive control cases. I work a little differently than some coaches. I work with people at an intersection of specific strategy for high complex divorces and coercive control, nervous system regulation, emotional processing, and I guess it was like project management of your entire divorce. So we work together very closely. When we're working together, we work together closely with your divorce team. I used to be a therapist, and then I owned a large wellness company and went through my own divorce with a narcissist and immediately somehow found myself another narcissist, got into a very up and down, very abusive, coercive control relationship. And it came and went many times, like we often do. It sometimes takes about 7 times to leave a relationship like this. And the last time I was getting ready to leave the relationship, my son died really unexpectedly, and it sent me back into the relationship. And I woke up one morning, maybe 6 months after my son passed away, and just thought to myself for the first time, none of this is my fault. Because often when we're in these relationships, were always wondering what's wrong with me. How did we get there? But for some reason, that morning I knew I needed to go. I needed to wake up. I needed to leave. And none of this was my fault. It had nothing to do with me. I called my sister, who had supported me many times in trying to leave. My brother-in-law showed up within a half hour with a U-Haul truck and boxes of Home Depot contractor bags. We packed everything up into this truck and we moved in with my sister. It was the end of the school year. Then my daughter and I went to Iceland for the summer to hide, bought a new house from Iceland, sold the company, and started doing what I'm doing today. And I've been divorced for about 14 years and work with people through my lived experience, through my education, and just being in the trenches with men and women going through these high conflict divorces. Did we do everyone?
Thank you, Lisa. We'll finish up with Tom.
Hey everyone, Tom Kilgallen. I'm a certified financial planner. I've been a CFP for the last 13 years. Thought I knew a lot about finance till I got separated myself a couple of years ago and realized I had no idea about all the ins and outs of the finances around dissolving a marriage, and really dug into that. Got my CDFA, Certified Divorce Financial Analyst designation. Then I published a book, The Divorce Financial Handbook, on Amazon. I put the link in the chat there. Just now I have the empathy to work with people in this really tough situation. I focus on trying to make sure everyone wants to know, are they going to be okay post-divorce? And I try and go into as much detail on that as I can and project not just through the transaction of the divorce, but what life's going to be looking like beyond the divorce financial. I do a free 30-minute consultation. I put a link to my calendar in there in the chat as well. But awesome to be here with this fantastic team that I've been working with. Got a real good team here.
Great, great. So now we're going to start the formal part of our presentation. And we love to start with our divorce coach, Lisa, to get us into a good grounded space so we can all be in a good place to receive the information and education that you'll be receiving tonight. So take it away, Lisa.
Hello again. Absolutely. I love to start with grounding work. I love to start with a little breath work because, as you said a minute ago, I work at the intersection of emotional regulation, nervous system regulation, and strategy. But no matter how amazing your strategy is, no matter how amazing your legal counsel is or your divorce team is, if you're coming from a place of a dysregulated nervous system, it often doesn't work. You're not able to think clearly. You're not able to see things from different perspectives. And you tend to have, I know I did, that spirally, pingy, overwhelmed feeling. If your nervous system is in a grounded, regulated place, you are going to be the one that is leading this divorce between you and your partner. You are the one that's going to have the clarity and the space to think. So, what I like to do before we even get started is just make sure you are super comfortable wherever you're sitting. Make sure you're warm. Grab a blanket, grab tea if you need to hop up and grab tea, grab wine. We don't care. We don't judge. Grab whatever you need and come back when you're ready. And then when you're ready, just sit where you are and start to close your eyes if you're comfortable with your eyes closed. I promise you, we can't see you because your cameras are off. So let your eyes just start to gently close. Let yourself take a giant exhale. Maybe it's your first exhale you've taken all day, maybe all week, maybe all year. Just allow yourself to be in a space that you're in for a minute. Starting to just notice your breath and letting it for now just breathe really naturally. Starting to notice any sounds you may hear in your room or outside of your home other than my voice. Maybe you start to notice the temperature of the room. Is it warm? Is it cold? Start to notice how your body feels, getting heavier and heavier where you're sitting, getting heavier and heavier on the seat that's underneath you and maybe behind you. If your feet are on the floor right now, noticing how they feel heavy and connected into the floor. And let's start to let you go into a little bit deeper breath now, taking nice deep inhales and nice deep exhales. Just take a second to fill the lungs up all the way, as much as it'll allow you to fill them up, holding that breath in there for a second, and then exhaling to release it out. Maybe you're picturing the breath as you inhale in, and you exhale up, traveling all the way up and down the length of your body. And as you're breathing, notice if you have any tight spots or tense spots. And if you do, that's okay. We're not going to do anything about it. We're not going to analyze it. We're just going to allow the tense and the tightness to be there and give it a little space to be recognized, to be seen. We all hold stress and tension in different places in our body. So just allow it to be. Continue that breath, not judging the tightness or the tension, just allowing. And now we're going to change up your breathing just a tiny bit, and we're going to start to breathe in a pattern of 5, 2, and 8. So we're going to inhale for a count of 5. If it feels comfortable and safe, we're going to hold that breath in for 2. And then we're going to do a nice big exhale for a count of 8. And we're going to just continue that breath for a little bit, inhaling in that 5, 2, 8 pattern, breathing at your own pace. And what this pattern of breath is doing is signaling to your nervous system that you're safe, that it's okay, that it's okay to breathe, that it's okay to let your guard down, that you're okay in this moment. We're just going to stay with that breath a little bit longer. And now you can stay with this breathing pattern. You can go back to natural breath. You can go back to some deeper inhales and exhales, whatever feels right to you for right now. With your eyes still closed, if they feel safe closed, let's start thinking about a time in your life where you felt really safe, where you felt really grounded, where you felt really content, where you felt really happy. It was think of a time and a place where this just, what the first thing that pops into your head. Then let's take you back to this time in this place. How old were you? What time of year was it? What were you doing? Maybe what were you wearing? And just notice as you think of this time and this place and this happy, safe, content feeling you were having. Picture where in your body you felt this emotion. Start to allow some of that safe, content feeling to come into your body now. And just notice what you notice. Notice where in your body you feel it. Notice maybe on a scale of 1 to 10 how strong it is. And what does it feel like? Does it feel warm? Does it feel cool? Does it feel tingly? Does it just feel relaxed? Just noticing whatever sensation you're feeling. And now we're just going to allow for about a minute that sensation to be there. Maybe it gets stronger. Maybe it gets lighter. Maybe it starts to move to other parts of your body. Just giving yourself this time to allow that sensation to be. Leaning into it, breathing into it, and just allowing it to be there. Knowing that this sensation is possible, that safety, joy, peace is all possible through this process of divorce and for the rest of your life. Knowing that you can always come back to this place, you can bring yourself back here at any time. Anytime you're feeling spirally, anytime you feel your nervous system kick on, you can come back to this moment and to this place. So we're going to stay in this place for just another minute. We're going to go back into those 5 to 8 breaths. So we're going to inhale for 5. We're going to hold for 2. And we're going to exhale for 8. Continuing to let the breath flow just like that. Letting yourself know that in this moment, everything is okay. In this moment, you are safe. In this moment, you are enough. In this moment, you are doing enough. Just slowly let's start to let your breath come back to whatever feels like a natural pace to you. Maybe we start to wiggle your feet a little. Maybe we start to move your hands. Maybe you start to move your neck from side to side. And slowly start to wake up. Slowly let your eyes open. Let yourself come back to the room and the space that you're in. And giving yourself just a moment to wake up, to come back to the room. And I'm going to start talking, but give yourself as much time and space as you need to come back into the room with us. So I'm going to talk a little about parenting and a little about parenting plans, just like a quick overview, and then we are going to move on to our next professional. Then when we begin our parenting plan, when we begin working with our team with our parenting plan, it's incredibly stressful. It's incredibly nerve-wracking, and it never fails to amp up our nervous system. And there's a lot of grief that comes with creating a parenting plan because you realize maybe you aren't going to be with your children 100% at a time. And there's a lot of questions, and there's a lot of what and ifs and buts and unknowns. And I always start with, when I'm working with clients, let's think about your day-to-day life, your children's day-to-day life, and what it looks like. What does your work schedule look like? What does your partner's schedule look like? What are your kids' activities? And how are we going to make this all fall into place and all work? Thinking about what works for your kids, of course, but also what works for you, your time, and your schedule logistically. Are you going to be able to get there after work? Are you going to be able to get them to daycare or school before work? And what needs to be in place for that to happen? Because if you're running around and you're constantly stressed and you're running from thing to thing, it's very hard to parent and to enjoy the time you have with your children. One of the biggest things that come up when I start working with people is that feeling of anxiety and sadness and loss of control for the times that they're not with their children. It's completely normal. There's nothing wrong with you. You're human. You're a parent. You love your children, and you are used to being there every single day. So I want to talk about this again in a minute, but coming up with some time, plans, schedules, things to do when your children are not with you is almost just as important as the parenting plan itself. And when I work with clients, I always work with them on this parenting plan and schedules and options. Because it's also very important to have as many details as you can in a parenting plan, especially in a high complex divorce. But even in a divorce, it's a little bit more amicable. It saves you going back to court. It saves disagreements. It gives you more expectation and grounding, and also lets your children begin to know what to expect. I have a template. I will send it to Mandy so she can send it out with an email tomorrow that will help everybody, if they want, to begin to work on it. So, really, there's many different options for way people parent. There's many different options for setting up the parenting plan, but there's two ways you can look at parenting. There's co-parenting and there's parallel parenting. Co-parenting is when it's a fairly amicable relationship. It's a fairly amicable divorce. There's no history of abuse. Or you can consider both parenting. I like to look at it like you're both in a car with your kid. And sometimes you're in the front seat of the car with your kids, and sometimes you're in the back seat of the car with your kids. But you're all in the same car, driving your kids to the same place, on the same path to the same destination. You work together and collaborate together when there's issues at school, when there's health issues. Maybe you're on the same page as far as discipline, as far as medical care, as far as maybe how your children eat. There may be some disagreements, there may be some bumps, but generally, you try to respect each other's opinion. You work together, you talk and collaborate. That's, of course, best case scenario. Then I think it's the question, somebody asked about how to parent with a narcissist or how to co-parent with a narcissist. My answer is you don't. You cannot co-parent with a narcissist. So that's where parallel parenting comes in. Parallel parenting is, if you visualize it differently, there's two train tracks. You're in one train track, your ex-partner's on another train track. And you both are parenting while you're on your own track. And your goal is to get your children to the end of the track. But your tracks never cross. You are parenting your way on your track. They're parenting their way on their track. There isn't a lot of collaboration. Unfortunately, there isn't a lot of back and forth because it can't be. Because when you're in a high complex relationship with a high conflict partner, they're going to use anything they can to alienate the kids against you. They're going to use it to control you. So you stay on your track, they stay on their track. And I could go into this more and more. If anyone wants to reach out, I will put all my information in the chat. And we really have to stay in our own lane as much as possible on our track with parallel parenting, unless in the case of there's something that's unhealthy and unsafe going on. And then when you work with your attorney to get involved. I highly in all co-parenting, but definitely in parallel parenting using a parenting app. I personally love our Family Wizard for my clients, just to keep everything schedules there. Anything financially related to the kids as far as reimbursements for sports is there. And also all the communication is there and documented. When you're parallel parenting and you're communicating with your ex, it's very important to communicate in a specific way to keep as much emotion as you can out of it and to keep as strong a boundary as you can so that you're not coming back to use that to control you. There's so many tips I could give you. I could talk about this all night long, but I know we have a time limitation, so I am going to pass this up to our next professional.
Thank you, Lisa. And next up, we have Tom, our financial professional, up on deck. Welcome, Tom.
That's awesome. Thank you, Lisa, for that. So Lisa works on a lot of the emotional regulation. Not that I'm empathetic, but conversations with me will usually be more numbers based. But it's all about building the right lifestyle, the right balance for you. We want to make sure you've the right time with your kids, a productive life, one where you're not constantly stressing over your lifestyle to the detriment of taking care of the kids and being focused while you're with the kids. But a lot of that is looking at, can you afford a certain lifestyle? We work on looking at a lot of cash flows and a lot of budgeting. People may have decisions over how much time the kids are going to spend with them. Depending on that, we'll have different budget scenarios. So we'd like to look at all your expenses to start with. And while it's difficult to project what your expenses are going to look like after you're divorced, it's a life you haven't lived yet. We're going to do our best to try and predict what that looks like. Things will change. It's going to be a different person, maybe doing the snow removal, maintenance of the lawns, etc., doing the housekeeping. But we'll look at those expenses and we'll break them all out. We'll also look at potentially if you're deciding on your level of custody arrangement, 50-50 versus 66-33, etc. What does that look like from a financial point of view? How is that going to impact your finances going forward? When you're structuring a deal in terms of alimony, what does that look like? We're looking at the assets in the deal as well, how that's broken out. Factors can come into play like, okay, what if you get alimony and decide to cohabitate in a few years and you lose the alimony? Will that blow up your plans? So I'm trying to, as much as possible, look beyond the divorce, the lifestyle beyond the divorce, beyond just the transaction. Have you come up with a sustainable plan? And a lot of that is, what are the kids' costs going to look like for college, for extracurricular sports, etc.? How much are you going to be able to afford there? What can you commit to do in terms of those spending goals around that? In divorce, we like to see that documented as much as possible. We come to agreement on who's going to pay for hockey and how much, or for the kids dancing or horse riding lessons, etc. But sometimes there's got to be a limit on that, depending on your resources, what your income's going to look like after alimony and child support, etc. So we're modeling out all those cash flows and making sure that your lifestyle is sustainable and you can do the best for the kids as you can without having to run yourself ragged, end up like working 2 or 3 jobs and ending up not having the resources, the time, the mental energy to be there present for your kids as well. So all that comes into play. It's all cash flows that we like to model out and project. So that's where I get involved, that side of things. Yeah, I'm going to be looking forward to some of the questions we're going to have later in the Q&A here. I'll pass you on to whoever's next on the list, Jolie.
Thank you, Tom. Next up, we're going to have our 2 real estate professionals, Maggie and David.
Thanks, Jolie. I know David and I work closely together along with Tom and everyone on the team to help you succeed. But a lot of times the home or future home is a big part of being successful post-divorce. As a certified divorce lending professional, myself, not just a loan officer, it's a different designation. So I am a licensed mortgage loan officer that helps people buy properties all day long, refinance, tap into equity. But I also have a special designation, certified divorce lending professional, which training on helping people through the divorce process because it could be different, calculating income and so on, which I'm going to go into some things specific to child support, alimony, and those parenting strategies. But I'll let my partner David say a few words and he can bounce it back to me.
Thank you, Maggie. And on the real estate side, the CDRE designation, it's relatively new in the real estate world, and it's rather important. But a lot of times divorce sales are looked on in a predatory manner from other realtors because they're just looking for a sale that they know is going to close. And honestly, like my role in these sales is actually to make sure, do we even have to sell? We exhaust all options before I heavily get involved. And along this way, it can be as early involvement, like valuing the home. If your attorney or Maggie or Tom need like a ballpark figure to use to figure out what's the equity in the house. If we were to sell it, what could we anticipate for proceeds? And then we don't like to actually push the sale unless it's agreed upon or it's mandated by the court. And usually where my role accelerates in addition to what regular realtors will do is having the police background. I have an understanding of evidentiary rules and things that could come up, because usually when it comes time to sell the house, things tend to get a little more heated. It can be a little more emotional. So in the event there's any sale sabotage or anything like that, I have means of being able to document what's going on, and if needed, explain to the counsel or the court why these are hindering the sale or affecting things. But we do it in a manner that's confidential. Believe it or not, changing familial status is a protected class. And so you'll see sometimes the listings when they're saying this is a divorce sale, it must go. We don't do that. We don't actually tell anyone that you're getting divorced unless we absolutely have to, because we're waiting on a court decision for approval. So the whole point is to keep your situation confidential and to get the household the best result. We work in a very unbiased manner, not taking sides with either party, but to make sure that the house moves forward, and knowing when to get your attorneys involved or to tag in other folks as well, Maggie, Tom, or anyone else along the way, because we don't always get referrals from the attorneys directly. Sometimes folks reach out directly to us. And like anything, even with a home purchase, I start them off on the financing side. Hey, do we need to do this? Are you exhausting your buyout options? And seeing if it actually has to go forward to a sale. So this is separate from my regular business. I'm not going to lose the roof over my head if I don't close one of these deals. There's a reason why we have this designation. It's to make sure that the level of professionalism is kept at a very high standard.
Yes, as you very much are keeping that level. And so when David and I, if we're working together, if somebody's going to have to sell and then maybe both parties are buying. So when I'm working with you, I'm really looking at what's your affordability. Sometimes one of the spouses might want to stay in the marital home, and it's their goal to buy out the other spouse. So that's that equity buyout that David mentioned. And sometimes that's possible. And sometimes we do the math together and we realize that kind of a reality check that maybe it's a better idea that the house gets sold. There are times when if Jolie has to take it to litigation and a judge is saying, I know I've got a client right now that she got an appraisal and the appraiser used all high comps and then deducted, and he got an appraisal and the guy used all low comps and then added things. And finally the judge is saying, hey, we need an expert opinion, and they might bring somebody like David in. Our job is really to help you, whether you're mediation, you're working together, or you're going through that collaborative law process or the litigation, whatever stage you're at, help you calculate these things. In terms of child support and alimony and parenting strategies, that's our topic for tonight. I wanted to talk about just child support. Usually the rule is that's a 636 rule. So you have to receive, if you're going to try to use child support or alimony as income to qualify on a mortgage, you need to have been receiving it for at least 6 months. And then the 36 is it needs to continue for 36 months, so for 3 years. So the 636 rule. So what that looks like is you may be in the divorce process, and once the separation agreement is finalized, you start receiving that first child support payment. And it has to be the exact amount for 6 consecutive months, and then we can start to use it. There are ways, though, that if you're in a mediation, for example, and you all decide ahead of time, maybe you're going to start that child support payment you're working with Marty and she's calculated out the income for the child support, you could start it early and that 6 months time frame clock is ticking as long as it's the same and consistent. And that might help the other person buy you out, right? So there's kind of some strategies, and that's why working with a CDLP like me and our other partners, doing it before you finalize the separation agreement helps you, especially if you're mediation and you're trying to make sure you're both successful post-divorce, to come up with that plan together. The other thing I wanted to mention is, so then on the opposite side is support payments. If your obligation is to pay alimony or child support, we have to factor that into your, what we call a debt to income ratio. So when we're looking at your total debts and obligations compared to your income, that's your debt to income ratio. And so child support is a monthly obligation that would just be like a car payment or a student loan. Alimony, we can look at a little differently. We can actually deduct it from your income instead of it being as a monthly liability, which does help that little calculation on the debt ratio. So there's little things like that someone like me makes sure to know when I'm helping qualify you or helping guide you on what you can afford. And then the other thing I wanted to mention tonight is, as you're creating these custody schedules and coming up with your parenting plan, at least in Massachusetts, and from what my colleagues here on the call have taught me, depending on the schedule, that can affect what those support payments are, right? Depending on that 50/50s custody or so on. And Jolie and Marty will get a little more into that. But so creating that plan and a solid plan ahead of time can really help then when we're looking at that mortgage plan and that equity buyout or those future home purchases. Having a solid plan on the parenting schedule really, it also helps affecting cash flow. And ultimately then myself, I work with Tom, we come up with what's going to be your best budget after post-divorce and making sure it's a long-term success. Something I know Tom can circle back on is, if you're the individual paying support income, and Tom, I don't know if you mentioned this, but he's taught me that the person paying the support should have an life insurance policy on them in case something happens. So there's all these little things that we're here to, with our knowledge together as a team, to be making sure that we're helping you come up with the best plan, understand how that affects your future goals in my job with the mortgage, and really just coming to terms with what's this long-term cash flow. Sometimes it's a reality check that you have to list the house and then we call David, right? And other times the equity buyout's going to work out. But then other times, for reasons unrelated to necessarily numbers, just emotionally or whatever, you all decide to sell the house. And then you need to know what each other can buy individually, right? So I'm here to help with all those things. Happy to do a 30-minute free consultation. Everything's in the chat. And I just wish you all much success. Back to you, David.
Yeah, as far as tonight's topic, not as fully involved as some of the others here. However, there are some crucial points to consider on the real estate side of things. Knowing what's going to happen with the alimony or child support if you plan on buying another home is crucial, because just like any other purchase, I can't effectively do my job until I know what budget you're working with. Or on the flip side of things, if you're selling the home, if there's going to be any type of arrangement for the split of proceeds, that's a legal question. I'm not an attorney. I can't answer that, but our attorney partners here, Julie and Marty, could actually dial that in for you. But it's important to know what's going to be happening, because if at closing, there's going to be a certain distribution of proceeds, maybe something's being held back or it's not a 50/50 split. We want to make sure that's all set up appropriately so there's no hiccups on the day of closing. As far as, oh, sorry, Maggie.
That's a good point. I like it. Yes.
Yeah, so it's one of those things that can be easily overlooked depending on if the closing attorney is not fully kept in the loop. So part of my role is keeping in touch with the attorneys involved and making sure, hey, we're a week before closing, this is final and everything going to be good, or if we need to make some adjustments, there are some workarounds to continue the close, but wait till everything's finished before everything's finalized. And then very importantly for my role is, if we are discussing a sale of the home and we have a parenting plan in place, this is obviously a very stressful situation for everyone involved, but especially the kids, and they don't need the extra stress of having to vacate the house multiple times a day, a week for showings and things like that. So depending on if they're staying in the home or where they're going to be, knowing that schedule can be very helpful on my side of things for making sure we can have a very smooth listing process without disrupting their life too much. So we would only try to schedule showings on the days that they're not at the home or the times they're not at the home, just to make sure that we don't have to continuously call, hey, everyone needs to get out of the house again. It's not a fun part of any home sale, let alone a divorce home sale. But the biggest thing is just staying heavily involved with everyone on both sides and their team as well to make sure that things keep moving forward effectively.
Great. Back to you, Jolie.
Sorry, forgot to unmute myself. Thank you, Maggie and David. So now Marty and I are going to come on to talk about the legal and mediation aspects of things. Just a quick disclaimer, because we are the attorneys of the group. Divorce law is state specific, and we are the Central Massachusetts Hub. So we will be giving a general overview of Massachusetts law. If you are in a different state, you will want to consult with an attorney who is licensed in your jurisdiction. So we are going to start with financial support. There are 3 primary types of financial support that are available in divorce. They are number 1, child support, number 2, child expense sharing, and number 3, alimony. So child support is money that is paid by one parent to another for the support, care, and maintenance of a minor or dependent child. And child support is intended to cover basics such as housing, food, clothing, and day-to-day expenses of children. This amount is determined by a formula, and in Massachusetts, it's called the Child Support Guidelines. The parent who has the children for the majority of time will receive child support. If the children live with both parents approximately equally, or we sometimes call it 50-50, then the parent with the higher income will pay child support to the other parent who has the lower income. Child support generally will continue until the child is age 18. However, it can continue beyond that age through graduation from college at age 23. Even if they're still in college, it stops at age 23. It can also continue to age 21 if the child still lives with a parent and is primarily financially still dependent on that parent. All right, Marty, do you want to go into child expense sharing?
Yeah. So, one other way that we're talking about support is to recognize that child support is not meant to include the costs of things like uninsured or uncovered health expenses of the children. And it generally does not include extraordinary expenses of the children, such as summer camp, tutoring, all the sports fees and lessons, all the extracurricular activities that are above and beyond the day to day. What we see typically is that these costs are usually shared by the parents. It's often 50-50, but not always. It is subject to negotiation. In Massachusetts, parents can also be ordered to contribute to college expenses, although, according to the statute, which Jolie had mentioned, that is part of the child support guidelines, most parents' contributions will be capped at 50% of the cost to attend UMass Amherst, which is the most expensive in state school in Massachusetts. So these are things that, when you're doing an agreement, that are usually going to be talked about and negotiated, or if it's going to trial and a judge is deciding, they're going to be weighing various factors to decide how these expenses are going to be shared and how they're going to be paid and things like that. Julie, I'm going to turn it back over to you for the fun of alimony.
So alimony is support that is paid by a higher earning spouse who has an ability to pay to support to a lower earning spouse who has a demonstrated need for support. And this is support that is for the spouse. So it's not for the children anymore. It's support for the spouse. And need is determined by reference to the lifestyle that the spouses enjoy during the marriage. So this can look very different across different households. Somebody who has an upper class lifestyle during the marriage would have a very different need than somebody who had a more modest middle class lifestyle during the marriage. In Massachusetts, the amount of alimony is not set by a formula like the child support guidelines are, However, a general guideline is the alimony amount often falls in the range of about 20 to 25% of the difference in income between the two spouses, plus or minus a few percentage points. So that's just a range. And judges have discretion over this range. The length of the payment. So, alimony payments have term limits that are based upon the length of the marriage. If a marriage is 20 years or more, this is determined to be a long term marriage in Massachusetts, and there is no term limit on alimony. It's called an unlimited term. However, alimony will generally end when the person paying it reaches normal Social Security retirement age, which for most people is age 67. However, this can be extended in compelling cases, and these are usually if there's disability or extenuating health circumstances for the person who is receiving alimony payment. Alimony will also end if either of the spouses passes away, or if the receiving spouse remarries, or if they cohabitate for a period of at least 3 months or more. Marty, do you want to talk about how alimony and child support can interrelate with one another?
Yes. So this is a big thing. And we're talking about Massachusetts law here. So one of the rules that we follow is that child support and alimony cannot be calculated using the same dollars. So after that, we end up with a lot of room for negotiation. So whether alimony and child support will be paid at the same time may depend on whether child support or alimony is calculated first. The child support is calculated based on the first $450,000 of combined spousal support. So this can get a little bit tricky. And there is, as Jolie said before, with alimony, there's so much discretion that's involved with this. So really working with professionals and trying to come up with how these things are going to work. There's some case law, there's things that we can get into. I know some folks have some questions about that we can answer. It's called the Kavanaugh case. But it is complicated. And the kind of joke around all of us for attorneys is when you ask us a question, the answer is it depends. It depends. It's so fact specific. And so we just have to really think about all of these different ways that it interplays and everybody's case ends up. I usually don't come up with the same answer twice. I don't know about you, Julie, but it always looks different in every case.
Sure does. So if you think that you have a case that could involve potentially both child support and alimony, I think it is wise to consult with professionals, an attorney, a mediator, possibly a financial professional, because these calculations are complex for us as professionals. So trying to do it as a lay person is very difficult. We can answer additional questions on that. But for now, we are going to move into the parenting strategy section of our presentation. So I think you're going to keep on going, Marty.
Yeah. Thanks, Julie. So, in many states, including Massachusetts, family court judges are tasked with rendering decisions in what we call the best interest of a child. So, a lot of people say, what does that mean? So, to begin this discussion, it's really important to note the differences between the two types of custody that we're talking about. And we're talking about first is legal custody. So there's two main components that we talk about and consider when we're talking about legal custody. The first is decision-making ability and authority relating to important issues related to a child. And those types of issues are generally medical decisions, decisions regarding their education, and anything regarding religion or around that. The other component of legal custody is the ability to obtain your child's records. So again, medical records, report cards, education records, and to be able to speak to their providers or teachers. So you're having one piece of it is access to your children's information. The other piece is the ability to actually make decisions regarding your child. So those are the two things we're talking about when we talk about legal custody. Jolie, you want to talk about physical custody?
Yes, thank you. So, physical custody pertains to where a child lives and resides. So, how do they spend their time between the two homes of their parents post divorce? We also talk about this in terms of the parenting time schedule. Some examples of common parenting time schedules are we call it a 2-2-3 schedule. So, this is a common kind of 50-50 or shared parenting time schedule. An example of this would be mom has the kids on Monday and Tuesday nights, dad has the kids on Wednesday and Thursday nights, and then the parents alternate weekends, so Friday through Sunday nights. This is a nice schedule because the kids have the same weekdays with the parents, and then the parties get to each have alternating weekends. When the kids are a little bit older, some parents like to do week on, week off schedule. So the kids will spend a week at mom's house and then a week at dad's house. This is also a popular schedule in the summer because you don't have to worry about school schedules and things like that. If parents live a little bit further apart, sometimes we'll do a schedule where one parent will have the kids mostly during the week, and then we'll go to another parent's on more weekend times or extended vacations, holidays, more time in the summer, things like that. Or if we're talking about if one parent has primary physical custody, more of this like 66-33 schedule that we heard Tom talk about, then the primary custodial parent might have most of the weekdays, and the non custodial parent would have alternating weekends and maybe either a dinner or an overnight on Wednesdays. You do have much more flexibility and customization of your parenting time schedule if you negotiate and or if you mediate and figure out a schedule with your co-parent instead of leaving it up to a judge to decide, because they're much more likely to go with one of these more standard schedules instead of taking into consideration your personal work schedules and your kids activity schedules. So that's something that I just like to mention. If take the time to sit down and try to work something out, you're much more likely to be happy with a schedule than if you leave it up to the roll of the dice with the court. Both types of custody, so legal custody and physical custody, can be either joint or shared, or one parent can have sole custody. Physical custody affects child support calculations and where a child may be eligible for school enrollment. Parents can also have joint legal custody, with one parent being designated as having final decision making authority in the event that the parties cannot agree on a particular issue. So they essentially become the tiebreaker. Otherwise, if parties have joint legal custody, both parents have to agree to make decisions for the children. If they cannot, then they would have to file a complaint for modification in the court and have a judge make a decision for them. All right, Marty, do you want to talk about some tips for more peaceful co-parenting?
Yeah, thanks, Jolie. And just to reiterate, as a mediator, and that's my primary job, I spend a lot of time talking about these things, all of these child support, alimony, the interrelationship, and the parenting plan. And that's really one of the things that if you're able to do that as part of the divorce process, you can create the schedule that works best for your family. Again, putting the best interests of your children and in the front of it versus leaving it up to a judge who's going to have very limited time and access and does not know your family and your unique situations. There's a lot of benefit in trying to figure out how to own that and keep control over it when possible. Now, as Lisa did a great talk about both co-parenting and parallel parenting. And the goal is to have a co-parenting relationship whenever possible. But sometimes it's not always possible for folks to be able to have those conversations with each other. And we do need to put some specific tools and strategies and boundaries in place. And so, one that's been very helpful, and I think Lisa actually mentioned this, is using the co parenting apps. Our Family Wizard app, there's actually a few more that are out there, but it's a way to document communication. It's one of my favorite things. When I was doing litigation, I spent so much time reading through. People would send me text messages and email them back and forth. And it's a lot of time for you to actually ask your attorney to be reading the messages to help you and your other parent try and figure out how to communicate. And these apps can streamline that for you. They document everything in a way that's very easy to read and digest. There's also things now, they have tone meters. as to what you say and whether that's going to be appropriate, trying to help you have communication that is effective, that's going to help in the best interest of your children. So you can do schedules on them, you can do payments on them, you can do calls on them. It's really become a very robust system as a way, instead of trying to share Google calendars and all the other things that I think we try and do to manage our children, that this is a kind of one stop for that. And that's what the intention of that is. Sometimes we need to have neutral location for drop off and pickup. So when we're crafting these agreements, many times we are going to put in there what the drop off and pickup requirements are, who's driving, where you're going to do those exchanges. Again, if we can do it at school when school is available, that's always one of the better options, because in particular cases where there's some high conflict, it minimizes the conflict between the parents. So we really want to be thinking about what is going to, again, be best for the kids so that there's minimal conflict and the parents don't have to have what could potentially be a challenging interaction. In some cases where the parents just are really unable to make co-parenting decisions or even parallel parenting decisions, again, the parallel parenting, they're in their own lanes, but sometimes they need to come to consensus. Again, depending if they've got shared custody, whether it be physical, particularly when there's legal custody, you need to have a third neutral party that can help. And so we have these things called parenting coordinators. And there's a couple different ways they can actually be appointed by the court. And there's a requirement, there's a standing order, there's a process that you need to go through to have a parenting coordinator assigned by the court, usually paid for by the parties. There's also other ways, there's some programs that you can use that are around parenting as well, that you could agree to hire a co-parenting person that's going to help you either reach decision or maybe be the final decision maker if the two of you can't. So it's something worthwhile to explore. And then the other option is working with a parenting coach or taking some of these parenting courses that are really educational, and they're about really centering your children, not putting your kids in the middle, but to really center the children and help you as parents be able to work through whatever that conflict that continues to keep arising as you're working, trying to parent your kids, to help you. It's not that you're not good parents, I think, but the stress of divorce, you're parenting differently, likely, than when you parented when you were one unit. And the stress, there's a lot of stress, there's a lot of things going on. And so having somebody who can be on your team, and either individually or as a team, two of you together. I've seen folks who have worked within the educational programs and hired their own coaches. And particularly in higher conflict cases, it can be, again, for the best interest of your child. So it's something that is a resource that is available to folks. So one kind of final note on this, when you do your separation agreement, if you're getting into an agreement, and you can get separation agreements, they don't always have to be done in mediation. Most cases don't go to trial, but anything regarding children, it's not set in stone. All issues pertaining to children are modifiable based on showing a substantial or material change in circumstances. If your kids are if you've got littles, like you're divorcing and your kids are like 6 and 8, the schedule that you put in place is not likely going to be the schedule when they're 14 and 16. So we do have to know that things have to change, and particularly in cases where your agreement doesn't specify it and you're not able to work that through with the other parent, you can go back and modify. So just knowing that anything regarding your kids, the court retains jurisdiction over it. And you can, if you meet that burden of the material change in circumstance, you can get a modification on that piece of it. Yeah.
Great. So we're going to invite all of our panelists to come back on now, and we'll answer any questions in the Q&A that we didn't get to yet, and any of the questions that were submitted in advance that we haven't gone over yet.
These separate condos being purchased while they're separated but still married, correct me if I'm wrong, Jolie, but those would definitely be considered marital property still.
Let's see. If both parents bought two separate condos after separation, would both of them be counted as marital home? So in Massachusetts, there's no such thing as a legal separation. That is a common misconception. So if any property is purchased while the parties are still legally married, all property is considered as marital property that will be divided during a divorce. So even if the parties are not residing together, those two condos would be part of the marital estate to be divided during divorce. All right. And then there's another question. With divorce pending, how can I get my ex to use our family wizard? He refuses. I already paid for both of our subscriptions. Yeah, this is tough. You could file a motion and ask the judge to order it. In my experience, judges are big fans of co-parenting apps. And if you can demonstrate that there's been a difficulty with communications, I think it's pretty likely that the judge will make it an order, especially if you've already paid for the subscription and it's just going unused.
I have a little trick that worked amazing for especially difficult partners. They're going to text you and email you because that's how you're communicating. Every answer, you screenshot their text and you put it in the app and you answer it in the app and you keep doing that. And they're going to come back and say, I'm not going to answer you. You have to talk to me. Your answer's in the app. It's going to take a few days. Sometimes it's even a few weeks, but eventually there's going to be an answer that's really important to them. And you will wear them down. They will push back and they will push back, but I've never had it not wear somebody down eventually. You just don't give them any other option, any other form of communication. And I especially you might even want to wait to start chatting to them something that's really important to them because toxic partners always care about what's in it for them. So wait until it's something that they care about, that they need from you, that they want, and then streamline it to the app and give them no other choice.
I love that, Lisa, because that is so much faster than emotion. So take that advice first. That's awesome. That's fantastic. All right. If your spouse filed for divorce the week before your 20-year anniversary, would it still be worth exploring long-term alimony? Otherwise, alimony will be for 10 years. Spouse is 57 until 67. Does the date one spouse moved out matter? If your spouse filed for divorce the week before your 20-year anniversary. So, Marty, I want to know your opinion on this, but it's the date of divorce, not the date they filed.
Usually, yeah, because a divorce could take 3 years. The other party could make the argument, but I haven't seen it be successful. So we're looking at spouses 57. It could be even with the 20-year marriage, it could still end on retirement age. So if somebody's at 57, I would say it's likely going to go to retirement age unless there's a compelling circumstance. So it's probably less of an issue. If somebody's 47, that might be a different issue entirely. So the 20 years could be more important. I don't know if it's going to be quite as important in this situation. And date of separation doesn't always matter. It just doesn't always matter. I think it's important for certain things. And when I do mediation, we try and talk about that. But again, we're trying to come to an agreement so that the parties can decide when their financial split is and all of that. Yeah. It's one of those, it depends, but I don't think that's going to be as much in this case. All right. Do we want to look at some of, I think, do we get all of them in there? Oh, there's a new one.
Oh, okay.
Oh, we just got a new one. It says, we've been separated and are coming up to 10 years at the end of May. If he files before then, will that put me in the 5 to 10 year length of marriage category? We're close and I'm nervous. The kids are young and the spouse is 45. So again, it's back to the date of the divorce. So you'll probably hit at the end of May, my guess is you're going to be in the 10 year. You're going to be at the 10-year mark. As I read that.
Yeah. 10 years at the end of May. And yeah, so it should be based on the date of your divorce, which will likely be beyond May. So you'll probably fall likely into the 10 to 15 year category.
And the other thing for this is your kids are young. So depending on how young your kids are, we've got to look at is
Child
spousal
support.
support and child support. You might not get both. A lot of times, depending on the age of your youngest child, it could be that the child support would actually go on longer than potentially the spousal support. And you're not necessarily looking at spousal support after. Again, it's just not clear cut. There's so many different considerations.
Yeah.
Yeah. Somebody says, I was told alimony is determined by date of filing, not date of divorce. I would say that depends. In my experience, that depends. Mediation, it's the date of filing because we're not going to a contested issue, right? So we've agreed to everything. It's the date of filing and then, or the date of filing and the date of divorce are very close if you do a mediated agreement. If you do a contested agreement, that's going to be either, again, you're going to agree or a judge is going to decide, and the judge has huge discretion. And I've seen judges do it in Essex County, where I do a lot of my practice. I see it more on date of divorce.
Maggie, do you have the questions that were submitted ahead of time by any chance?
Sorry, yes. I'm just toggling back and forth here. One we haven't answered yet. Let's see. Sorry, that was answered. How do we try? I think you guys answered this. Is alimony calculated differently from state to state? You did. Which factors are considered for alimony in Connecticut? Which I don't know. You can't talk specific, but is there a huge difference between state to state, guys?
It depends.
It depends.
I-
Marty's favorite response. I was kidding.
It really does. Every state does it differently.
Yeah.
Yeah.
Are financial decisions negotiated during a legal separation legally binding? What's the difference between financial support decisions made during a separation agreement versus a divorce?
I will take that if you want, Julie. I think there is no such thing as a legal separation in Massachusetts. And so even though we call it a separation agreement in Massachusetts, that's the legal contract that you're going to file with the court, and that's going to ultimately become the divorce decree. So if you're in, I do this a lot of times with folks in mediation, we can sign a contract or an agreement, like something that you guys are going to say that you're going to uphold, but it doesn't have the same binding legal effect as a final divorce agreement because you're not within the jurisdiction of the court at the time. So it's in other states that might have legal separation. I can't speak to that. I think that there are guidelines and things that are in effect. If you're in litigation, once you've filed in court, you can get temporary orders, and those have legal significance, whether you agree to them or not, or whether a judge orders them. Those are binding court orders that have a legal impact. But if you two just decide to write something down and say, this is our agreement, it likely won't hold the same because we don't have legal separation in Massachusetts.
Okay. I saw two questions that were very similar. Can you mandate child support for someone that's graduated college already, even if that kid is having trouble getting a job, etc.? Can you look for child support for that kid?
Yeah. No.
Yeah.
I had that conversation recently with a couple folks, and I get it that they're dependent on you, but legally the court, there's no jurisdiction. They are emancipated. And if you choose to support them, it's a voluntary choice. That is your choice and you're making it. You can't legally go after the other parent and ask for child support. Once they turn 18, 21, or 23, depending on where they fall in the statute, they are responsible for themselves.
If you're graduated college before you're 23, does it go to 23 or just till you're graduated college?
Just till you graduate.
Graduated.
Okay.
Yeah.
Got it.
Yeah. So if you get an early graduator, which I had a 22-year-old, and yeah, the child support ends once they graduate.
We have a question. How do you calculate income when you own an S Corp business and account for the owner's draws, etc.? I know we talked about this as a group before. And I just want to say from a mortgage, when we're calculating income on when you're a sole proprietor, say, or the S Corp, we're looking at that bottom line number on the tax return, but then we're adding back things like depreciation. And there's some certain things that we can add back. So that's from an underwriter perspective. But I want to give it to Marty and Julie on when you're calculating child support and alimony.
Yeah. So this question is it depends on who I'm representing in this situation. So if I'm representing the business owner, I want to put on the financial statement what he or she is taking as owner's draws for the company to represent the income. If I'm representing the other party in the divorce, I want to see everything that is available to that business owner as available income. What is the bottom line? What's the net profit of the business at the end of the year? Because that is available income that they could take as owner's draws. I want to add back in depreciation. I want to see if any personal expenses are being paid through the business. It depends on which side I am representing. And then you make your arguments to the judge and see what they think should be the accurate income for support purposes. So it's not as clear cut.
It's not. And in mediation, we're going to talk about all those things. They're all up for negotiation and conversation. I think that's part of, again, it goes back to having control over what the parties need. So it depends. I think we got a couple more live questions in the chat. I just saw it said, somebody asked, can you explain more about having a percent of RSUs awarded as alimony, 15 to 20%? I'm not sure what the RSU is.
A restricted
Ours-
stock unit.
Plus,
Restricted
Oh,
stock
that's
unit.
right.
So this is interesting. So this to me, and RSUs are usually divided as part of the equitable division of the marital estate. So to me, this is more of a buyout of alimony, like as a lump sum instead
Yep.
of a regular or periodic alimony payment. So you would want to see what your general term alimony payment would be compared to what the percentage of the RSUs would be. Usually, if you're getting a lump sum up front, the payor is getting a credit for paying you a lump sum. So you're going to want to do some calculations and talk to a financial person like Tom and see if this is a good deal for you or not.
Yeah.
RSUs in Massachusetts, how they're divided in a divorce is based on something called the Baconti formula. It's based off of a
Mhm.
case precedent. So you're also going to talk to Tom, somebody like Tom, to see how this factors into it as well.
And the one thing we didn't say about alimony and child support is the tax implications. So, child support, both actually are paid in after tax dollars by the payor. So, they are paying, we base it on your gross income, but you pay it on your net income and they are not taxable to the person who is receiving it. So again, like something like this, you got to just, I always bring Tom or someone like Tom in to be able to help with these analyses because
Yeah.
it's not equal, right? Like sometimes what looks
Right.
like the same dollar numbers is not the same dollar number. If someone's getting $50,000 in child support a year, that's actually like whatever percentage, whatever their tax percentage is, it's a much higher amount because they're
Right.
not necessarily paying taxes on it.
Definitely, yeah. Anytime in the divorce negotiations, you want to look at the after-tax number in particular, as you said, because person paying the alimony has got to pay taxes first, then pay that, and they don't get a credit for that. And it goes to assets when you're receiving assets as well. $1 in CDs or in a brokerage, like in a checking account, is not worth the same as $1 in a house or $1 in a 401k or an IRA. Because you've got to look at the after tax, what you're getting after taxes. So that's where I would come in to help with those calculations. So when you're talking alimony, child support, for sure, you want to look at what you're taking home after you've paid those and after taxes or received those.
I didn't think about that when in terms of on the qualifying too, because on child support, you can always we can gross up the child support income by 25%. Okay, for qualifying purposes. And then alimony, you could do that as well as long as it's definitely, you have to make sure it's definitely not taxed, but certain requirements there. But most of the time we can gross both of them up by 25%. So when you're trying to qualify, let's say you're getting $100 a month, I know that's low, but easy math today for child support, we can actually treat that as 125. Yeah.
Yeah. So it makes a difference. And that's why everything is so fact specific. And we have to run, as Jolie was saying, we run a lot of different calculations to figure all of these scenarios out so that we can look at it because if somebody has what their gross is, it looks big, but then when you actually start looking at what their tax debt and all of that, what their net is, and then add a payment on, and again, there's some complexities there as to what we're trying to accomplish. For sure. Somebody also said, what impact on asset division does a spouse putting a real estate assets into a trust for the children prior to divorce filing?
I have a case going on with something similar like that where one of the spouses is trying to have the judge insist on the other spouse putting it in an irrevocable trust, which would ensure that then those assets continue for the children. In this case, they're adult children. There's so much going back and forth where now I'm involved because from a mortgage perspective, then you really can't finance on an irrevocable trust. And so when you're dividing that and setting up those trusts, you also want to make sure. My argument to them was by doing an irrevocable trust, sure, the mom is that means my kids will always have that asset, but it actually will stop the husband from refinancing the mortgage, which is, in my opinion, future earnings for the children. Because if he could reduce that mortgage interest and be paying more of that principal, or if he could leverage it and buy something else, as long as it's always staying in the revocable trust, it could be in their name and he could end up with more property for them or whatever, grow the asset. So anyway, just want to be careful on what type of trust you're doing for those kids.
Yeah.
I
Yeah. Go ahead, Tom. Sorry.
Revocable, it's still very much marital, correct?
Yeah, that's what I was gonna say. This sounds to me like this was done for like estate planning purposes. Like you usually put your trusts, some bank accounts into a revocable trust to avoid probate in the future. And so if your spouse put your house into a revocable trust for estate planning purposes, it's revocable, so it can be undone, and this house is still up for equitable division in the divorce. That's what I'm taking away from this question. What do you think, Marty?
Yeah, I am too. I am too. I think, again, it's depending on what the intent was and how that was done. It doesn't necessarily take it out as a marital asset in the division. Yeah. Yeah. There's another question. Oh, do we have time for another one?
One more, yeah.
Let's see.
Means 36, the financial support, child plus alimony should continue. If the spouse starts contributing before 36 months, the spousal support ends. When I was thinking about we need it to be 36, need it to continue for at least 36 months for us to use it for qualifying purposes on a mortgage. Marty, what were you going to say?
Yeah, if the spouse receiving cohabitates with someone, that is one potential event that could trigger the ending of spousal support. So I guess that could impact the mortgage, the lending piece, I would assume. That's probably something somebody should know.
Yeah, because if they cohabitated before the 36, yep, they're going to lose that support. Now, is the lender going to circle back and police that? No, that would fall more like they would no longer, just if you lost your job after you took a mortgage, right? Nobody's going to come back to you and take the house away.
This last one, I think it's an interesting one, really. It says, my attorney is suggesting we ask for alimony instead of child support because it's higher and it's unlikely a judge would approve my request for both. Does this seem successful in your experience? So Kavanaugh's going to come in, right? Because aren't they going to want you to run both? Like the judge is going to want you to run both.
Yeah. So under Kavanaugh, you're going to have to run all of the calculations. You're going to have to run child support. You're going to have to run child support first, alimony second. Then you're going to have to switch it, run alimony first, child support second. And then they're going to want to see the tax consequences. And this will probably it's going to be at a motion hearing or it's going to be at a pretrial. And the judge is going to tell you what they think is the number.
And they come in pretty close, I have to say, when I've done them. It's not as huge of a difference as people think. And again, I get back to what we said before. The judge has discretion on how they're going to ultimately, particularly around the alimony piece. So it's a strategic move. And I think it's important to talk with your attorney and have gone through all of the different analysis and see what your options are.
And sometimes I've seen judges do things where they've done an upwards deviation of child support. So it's in the middle of the alimony number and the child support number. So it's a little bit of a compromise, but that's how they justify it. It could come out either way, but your attorney is there to advise you and they know all of the details of your case. So they're in the best position to advise you on what to do. But it's funny because the only one whose opinion matters in all of this is the judge, and you're going to get their opinion. So once you provide them with all the calculations.
Yeah.
But yeah, so that brings us to time for tonight. Thank you so much for sticking with us through the entire presentation. We hope that you found it valuable. Please feel free to reach out to us with the contact information we provided in the chat, and we wish you the best of luck in your journey and have a great evening. Take care.
Bye-bye.